Police can seize your car during a routine traffic stop, even if you have done nothing wrong. You heard that right. You have not been charged, you have not been arrested, but your car is gone. And in most of the United States, law enforcement does not have to give you a quick court hearing to get it back. They can keep it for months while you fight through civil paperwork that has nothing to do with criminal charges against you. This is not a hypothetical scenario dreamed up by legal theorists. In 2019, 2 Alabama women learned exactly how this works when police took their vehicles and held them for nearly a year.
The case went all the way to the Supreme Court. And what the court decided in May 2024 affects every driver in America. Halima Tarifa Cully and Lena Sutton were not criminals.
They had no arrest records. They were not present when the stops occurred. Cully's son had been driving her car on February 17, 2019, when police pulled him over and found marijuana. Sutton had lent her vehicle to a friend whom police stopped later that year under similar circumstances. When officers discovered drugs in both cars, they did not merely arrest the drivers. They seized the vehicles themselves under a process called civil forfeiture, a legal mechanism where the government takes property suspected of being involved in a crime and forces the owner to prove the property is innocent. Police never charged the women with a crime. Yet the state of Alabama treated their cars as guilty simply because someone else had committed an offense inside them. Cully and Sutton had to hire lawyers, file claims in state court, and wait roughly 14 months before they recovered their property. Then they sued in federal court, arguing that the Constitution guaranteed them a prompt hearing before the government could keep their cars. The state disagreed. It argued that the ordinary civil forfeiture timeline was sufficient. The federal district courts rejected the women's claims. The 11th Circuit agreed with the state, so they took their case to the highest court in the country. Unlike criminal forfeiture, no conviction is required for civil forfeiture. The government does not sue you, it sues your property. That is why federal dockets contain absurd titles like United States versus one 1974 Cadillac Eldorado. Yes, the government is suing a pile of metal, not a person, because metal has no right to remain silent, and it cannot prove its own innocence. The burden falls on the owner to intervene, hire counsel, and demonstrate that they had no knowledge of the illegal activity. It is a civil procedure disguised as a punishment, and it operates on a backward premise. Your property is presumed guilty, and you must prove it innocent. This practice generates staggering numbers. The Department of Justice reported 4,253 seizures in 2021 alone. That is 11 families losing their cars every single day of the year. And those are only the federal cases. A single state like Arkansas saw more than 9,500 vehicles taken between 2010 and 2014, a state with fewer residents than the city of Chicago. Philadelphia seized roughly 3,500 cars over a 12-year period. Many of these vehicles are worth less than the cost of hiring an attorney to fight the seizure. One Georgia study found the average seized vehicle valued at approximately $2,200. That is less than the price of a decade-old used sedan. Owners frequently abandon their property rather than pay legal fees that exceed the car's worth.
Would you spend $5,000 on legal fees to recover a $2,000 car? Or would you let the system win? The government knows this. The system is built on it.
Cully and Sutton faced this machinery in 2019. Police stopped Cully's son on February 17th. Officers found marijuana and seized the car. Police stopped Sutton's friend later that year under similar circumstances. Both women filed claims of innocent ownership in Alabama state court. They argued they did not know their vehicles would be used for illegal purposes. Cully recovered her car in May 2020. Sutton recovered hers in April 2020. The process took roughly 14 months from seizure to return.
During that time, they paid for alternative transportation, legal fees, and the ongoing stress of proving their own innocence to reclaim their own property. But they did not stop there. Both women filed federal lawsuits under Section 1983, a federal statute that allows individuals to sue state officials for constitutional violations. But they did not stop there.
They claimed the Due Process Clause, the constitutional guarantee that the government cannot deprive you of life, liberty, or property without fair legal process, required Alabama to provide a preliminary hearing shortly after seizure. A preliminary hearing is a brief court appearance where the government must show some evidence that the seizure is legitimate. It is not a full trial. It is a checkpoint. The women wanted this checkpoint to prevent the government from holding their cars for months while the slow civil forfeiture process dragged on. The federal district courts rejected their claims, applying a standard from a 1983 Supreme Court decision called United States v. $8,850. Under that precedent, the Constitution only requires a timely forfeiture hearing, not a separate preliminary process to challenge the seizure immediately. The 11th Circuit affirmed in July 2022.
It applied the Barker versus Wingo test, a four-part framework that examines whether delay violates due process by weighing the length of delay, the reason for it, the claimant's assertion of their rights, and the prejudice suffered. The court found no constitutional violation.
Other circuits had reached different conclusions, some applying the Matthews versus Eldridge framework, a three-factor balancing test that weighs the private interest affected, the risk of erroneous deprivation, and the government's interest. That split between circuits made Supreme Court review likely because the same constitutional right was being interpreted differently depending on which state you lived in. The court granted certiorari in April 2023, meaning it agreed to hear the case. Oral argument followed on October 30th, 2023. Several justices expressed concern. Justice Sotomayor questioned whether innocent owners were receiving adequate protection against prolonged government retention of their property. Justice Gorsuch suggested the existing precedent might be due for re-examination in light of how civil forfeiture has expanded since the 1980s. But the majority saw the issue differently. On May 9th, 2024, the Supreme Court issued its decision in Cully versus Marshall. Justice Kavanaugh wrote for a 6-member majority. Chief Justice Roberts and Justices Thomas, Alito, Gorsuch, and Barrett joined. The court held that the Due Process Clause does not require a separate preliminary hearing for innocent owners of personal property seized under civil forfeiture. A timely forfeiture hearing is constitutionally sufficient. The majority reasoned that the court had already decided this question in 1983 and 1986 in United States versus $8,850 and United States versus von Neumann. The court ruled that the Constitution demands only a prompt hearing within a reasonable time after the government initiates forfeiture proceedings. Kavanaugh emphasized that these precedents directly controlled the outcome. Alabama had provided hearings within weeks or months. That was enough. The majority also pointed to historical practice, noting that separate preliminary hearings for forfeiture were not a traditional requirement. But here is what changes everything about this story. The plaintiffs did not ask the Supreme Court to end civil forfeiture. They asked only whether innocent owners get a fast hearing to challenge the seizure. The court said no. That means the burden remains exactly where it has always been. On you. Justice Gorsuch, joined by Justice Thomas, wrote separately. They concurred in the judgment, but suggested the court should reconsider the broader framework of modern civil forfeiture. They noted that the practice has expanded dramatically since the 1980s, and that the current system places heavy burdens on property owners who must prove their own innocence, while the government holds their property indefinitely. Justice Sotomayor dissented, joined by Justices Kagan and Jackson. She argued that the majority read the old precedents too broadly. The question presented was narrow: whether innocent owners deserve a preliminary hearing before their property is held for months. The majority's answer, she contended, swept far wider than necessary and left property owners with minimal protection against lengthy government retention of their vehicles. She pointed out that the 1983 and 1986 cases involved different circumstances and did not squarely address the plight of innocent owners caught in the modern forfeiture system. The vote was 6-3. The practical effect is immediate. Police in most jurisdictions may continue seizing vehicles during traffic stops without providing a quick judicial review. Owners must still navigate the civil forfeiture process, which can take months, while paying for alternative transportation and legal representation. The court spent 32 pages debating one question. Is waiting 14 months for your own car a constitutional violation? Their answer was 3 words long. Technically, no. American due process at its most efficient. If this happens to you, there are 3 hard truths you need to know. First, a police report is not enough. Photograph everything yourself. Get the officer's name, the agency, the badge number, and every piece of paper you receive. Second, this is not a criminal case, and the deadlines are brutal. In some states, you have 30 days to file a claim. Miss that window, and you can lose your property permanently, even if you are never charged with a crime. The state does not have to prove you guilty. You have to prove your car innocent. Third, I did not know will not cut it. Gather title documents, registration, insurance records, and any evidence that you had no idea your vehicle would be used illegally. Some states allow hardship petitions. If you need the car for work, school, or medical appointments, ask your attorney whether this applies where you live. The Cully decision means you are not constitutionally entitled to a quick hearing to force the government to justify the seizure up front. The case will proceed on the state's timeline, not yours. Understanding your local forfeiture statutes before you need them is not paranoia. It is your only shot at protecting your property. It is preparation. The government can take your property without charging you with a crime. The Supreme Court has said that process, however slow, is usually enough. If you think that standard should be different, the debate is moving to state legislatures, where several states have already passed reforms requiring prompt hearings and raising the evidentiary threshold for seizures. Next week, we are looking at the unlimited paid time off policy. That sounds like a dream, but is actually a massive legal loophole designed to avoid paying you for unused vacation. Your company is not giving you freedom. They are erasing your rights. You'll want to see that one.